Thank you so much, Sujata. Thank you, Sarosh, for making the long trip from London to Jaipur to talk to us about your journey. It's um, it's a book which is sometimes reads a bit like a Bollywood film script. It's got thugs, it's got mafia, it's got semi-disguised mafia, but at heart, it's a personal journey. It's a journey of a young man who decided that he was not going to fall into the comfortable rut of inheriting his father's legal practice in Bombay, but moved to the UK. So let's begin with the beginning, Sarosh. Where did this idea come from, and what gave you the spunk to go and make it happen?
First of all, may I thanks the organizers for inviting me. It is the first time I've been interviewed in India, which is a great joy, and congratulations on the great success of this thing. When I was an Indian student, a student in India,
Sarosh, can you hold me?
I always wanted to join politics, and I wanted to change India. In fact, as I said in my book, there were two or three of us at the Government Law College in Bombay, and all three of us wanted to be the Prime Minister of India. One was Maruzban Patrawala, who came with me to London to qualify for bar, and then he became a minister in the Maharashtra Assembly, and then he contested a parliament seat against Murli Devra, fell out, and Pochav died of a heart attack. The second was Firdosh Talia Khan. His father was a minister in Maharashtra again, and he was a mountain climber, and he died in the Himalayan mountains, so I was the only one left behind. And I do believe that India has a future internationally. India has always been a great country, but it was because of the colonial rule we became a sort of second-rate country for some time, so we should get back. I went to qualify, and my aim was to come back to India and join politics. And then I found that let me start a firm, and the motivation to start came from an eminent arbitrator called Cedric Barclay. And he told me, he said, look, what are you going to do? I said, I'm going to work for a year or 2 years and then go back. And he said, no, don't do that, because if you join a big English firm, every year the senior partner will take you for lunch and say, good job, old boy, and you will stay where you are. And the white people will go ahead of you, and you will remain in the same position for 20 years. So I started. And I decided I'm going to start in the city of London, which is a completely white area. Right? And I decided I'm going to keep my Indian name, because there were a few Indian Pakistani firms, but they were not in the city. They were in the suburbs, and they were doing immigration. But they all adopted an English name. They either Johnson and Johnson or some English name, because they were shy of the Indian name. So I started with the Indian name, and we started. I was very lucky that the High Commissioner at those days was Syed Mohammed, was Indira Gandhi's, some of you might remember, was Indira Gandhi's Minister for State for Law during emergency. So when Mrs. Gandhi came back, he was made the High Commissioner, but he was also a former Advocate General of Kerala, so he was a barrister himself. And he saw a young Parsi boy starting a firm near his High Commission, so he appointed me as an Indian High Commission solicitor. That was a great, great experience. And one of the very first cases I did in my first 2 years was a shipping case called La Pintada. In those years, India was going through a famine, and President Johnson had donated wheat under PL 480 scheme, and India had to charter ships to bring the food. And Indian government always paid the debt of freight and demurrage late. So this is quite an interesting case, because it came to me, it was supposed to be hopeless case. The barrister said no chance of succeeding, where the compound interest could be paid by the debtor for the late payment of debt. And all the shipping barristers said, no, there's no chance at all. But I was convinced that this is wrong, because you're making India a voluntary banker by paying compound interest. And then, believe it or not, Tony Blair was a young barrister, but in the labor chambers. And shipping was always an upmarket, so he contacted me, said, I would like to work with you. And I took him on. This is a true story. See, this is how things move. And I took him on. I said, will you argue this case in court? Because in those days, we solicitors were not allowed to argue in court. Now we are allowed. So he said, yeah, I will do whatever you want me to do. And he said, come and meet my senior, who was Derry Irwin, who became his Lord Chancellor when he became the Prime Minister. And they said, yes, we'll argue. An hour before, Tony Blair called me up. It's in my book, and this is the whole English bar knows about the story. And he phoned me up, and he says, Derry Irwin, his senior, wants me to come to the High Commission with a senior representative of the Indian government present. So I took Mrs. Charawala, who was the legal department, And Derry Irwin, who later on became Lord Irwin, said there's no hope in hell that you will succeed. You spoil Indian government name by taking a completely wrong point. I said, no, go on. They were completely unprepared. Martin Morwick QC, who's now become a judge, Court of Appeal judge and all the thing, and came before Mr. Justice Stoughton, and we won. It was remitted back. And I went back before the arbitrator, because arbitrators I used to appear myself. We lost again. It came back before Mr. Justice Stoughton. We went to the House of Lords and won 5 times. Consequently, when it came back, I had to sack Tony Blair. And in 2003, this is a true story, David Lepard, the English bar and English press knows about it. David Lepard, deputy assistant editor of Sunday Times, took me out for lunch, and he said he wants to write a story that if he had pleased me and he had remained at the bar means the barristers, he would not have joined politics, and the world would have been saved the Iraq War. So this is also good luck. Now I'll tell you how I met Tony Blair. This is okay. Hindujas, besides the High Commission, Hindujas were my first client, but it was different Hindujas. There were just 4 brothers came from Iran, small office, and they had sent me to Iran to collect some. At that time they were traders, supplying grains and everything. And I went to Iran, and that was just after the revolution. And I was sitting in a hotel, which is completely empty, but there were 3 or 4 Parsis, ship captains, and they got to know me. And one of them had an arbitration in Dubai. He recommended me, and that was in New Orleans, construction of a Jumeirah Beach Resort Hotel in Dubai. Now, Tony Blair was a junior counsel in .K, so that's how I first met Tony Blair. So it's also luck and chance, but how you handle the situation that makes a lot of difference. So this is my beginning.
So you're the man who sacked Tony Blair. Yeah, at that point in time.
Tony and I are still very close friends.
Good to know, good to know. Otherwise, you may have had a problem with your immigration status in the UK.
I had a problem before.
Okay.
I had a problem before, and in fact, it was Michael Beloff who wrote a book just now, but he mentioned my name. Because I went to qualify, I went as a student, and I did my training contract. But to work, I needed a work permit. So I had to go back, stay for 4 months in India, and get a work permit and go back.
Right, right. So, what were the kind of issues you faced in terms of breaking into the market? You had an easy start in a sense, working with the Indian High Commission, and but you obviously couldn't make a career out of just working for the Indian High Commission, nor would you have liked to. So what was the effort in terms of breaking out of this circuit and the acceptance of a brown man in a very white profession?
Okay, may I be very honest with you? The difficulty I faced was mainly from the other Indian businesses. Because somehow or the other, they had a complex. They thought an Indian lawyer cannot face an English judge or English arbitrators. And therefore, what I did was that I started marketing internationally, avoiding India to some extent. And we had lots of Greek ship owners and lots of other international clients who came to us. So the general rule amongst the white English people were that so long as you acted for Indian clients, fine, but you can't come in our market. So that had to be broken. It took me some years to break that, but fortunately it is now broken, and now we have an Indian origin prime minister.
Sure.
And we have seen things changing.
Sure. But there's a very interesting series of incidents that you relate, which had to do with the Britannia matter. Not the Britannia biscuits that we know about over here, but your whole effort to represent an Indian shipping company, but through a British club of insurers. And I think that has many lessons in terms of the difficulty of breaking into a white market.
Well, I did that as a matter of principle, because it was at a stage where it didn't matter to me whether they came or not. But Ravi Roya of SR Commodity was a good friend. He instructed his team to use our firm for the shipping cases. And the way it works is that the legal fees of a ship are paid by insurance PN, they're called Protection Indemnity Club. And there was a club called the Britannia PNI Club, which was covering the legal fees insurance. And they did not like Indians coming into the market. So I was told that, look, there's an objection. So I said, no, you have a right to appoint whoever you want as a solicitor under the club insurance cover. And they appointed me. But there was a problem. So I went and met the chairman of the club, Mr. Patterson, and he told me quite bluntly, I knew him as a friend. He said, my boys don't trust Indians. Exactly, and he never disputed that. He said, my boys don't trust Indians. Fortunately, one of the things which I had done in order to break the barrier was I had built up a network of powerful political friends, including the Prime Minister. John Major was a lovely man. We met and we liked each other. And I believed that we had to break the mold. So I had also organized the first ever dinner at 10 Downing Street, presided by the British Prime Minister, John Major, for Asian businesses. So I had the contact. So I wrote to the Prime Minister. In my book, there's a letter from the Prime Minister that I will not tolerate racial discrimination. But he soon lost the election. Tony Blair came. And Tony Blair also said that he said, Delhi will look a hard and long look at what you say. Now, they have a quite openly, they said, my boys don't trust Indians, just Indians. So the government decided, not me, to take the club to the Race Relations Board. At the Race Relations Board, they said, no, it was not Indian race, but Indian style. So that went on for such a long time. Everything was done to knock me out. And ultimately, I was part of the British delegation with the Lord Chief Justice Wolf in Malaysia, when they were going to make criticism of the Malaysian government interfering with the judges and discrimination, all that thing. And I told Lord Wolf that I'm going to say it happens in India too. And we then had a deal. He said, don't say anything. Come and meet me, we'll sort it out. And after that, the whole thing started. But what had happened was that Derry Irwin was Tony Blair's Lord Chancellor for 10 years. He appointed a tribunal into the conduct of 3 Court of Appeal judges, because what had happened was that before the race relations proceedings, at a different, entirely unrelated case, 3 Court of Appeal judges, knowing that it was quite a public issue, that this hearing is going to go on, made some irresponsible comments about my conduct. So that was the issue on which the government decided to wait to remove the race relations proceedings. So ultimately, the Lord Chief Justice gave me an assurance that we are going to change. It was only after that the first non-white judge was appointed by the English court. Even today, there's only one non-white judge, Mr. Justice Singh. So things are changing, but we have to accept that unlike United States, which is a country of immigrants, Britain is a country of natives. So we have to gently handle it. I'm sure I read about it. There were campaigns, there were attacks on Nigerian students here. So that is also, we have to respect that Britain is not a country of immigrants. Britain is a country of natives.
Just to set the record straight on that particular matter, you're saying that the case did not finally get heard?
No, it did not. It was withdrawn.
And what happened to the instructions that Ruya gave to the PNI club? Were you able to then handle Ruya matters or not?
No, we were not able to handle it.
I see.
But we were not able to handle it, but that was all right. But the point was made. And to me, it was because we are quite busy now. We act for Venezuela, we act for Iran, we have acted for Russia, and for many years we acted for China. We were officially Chinese government lawyers in international arbitration cases. My firm was the second international firm in Beijing after Clifford Chance. And we were officially sponsored by the Chinese government at their invitation.
Sure. So there's another incident that you talk about in the book where, again, from the point of view of escaping this sort of Indian badge and the kind of difficulties that it creates, of appointing a senior English counsel as a member of your company. Mr. Milne, I believe his name was.
Yeah.
And that didn't work out really well for you. So can you explain what was the kind of thinking that went on and that whole experience?
I think it's a fascinating experience, and every experience made me stronger. Because John Major and I were pretty close friends. In fact, I came on the Concorde flight, the only Concorde flight to India. We stayed here for 6 days. I was part of the British team, and I went with Michael Heseltine to China. What happened was that I had appointed a solicitor from a big firm to become a partner, English chap, and he had stolen money. And when his theft was discovered, he blackmailed me, and he wanted to so he made the allegation. At that time, I was offered a knighthood, first the CBE and then a knighthood, But he made an allegation that I had paid the ministers millions of pounds. And so that was the problem which we had. Ultimately, that was all resolved. And it was completely untrue. But so the British had a way of dealing things too. But that was not a big incident.
Okay, okay. There was another incident that you talked about where you found that somebody else was abstracting money from your organization. This is not a sense that one generally has of business practices in the UK. So, what is the reality?
Reality, people are the same. It's partly it's my fault because I've always been very trusting, and to me, getting the legal work is a priority, not money. Money comes and goes. What had happened in that particular case was that I was from 10 Downing Street. Lord Feldman had come to me and said the Prime Minister decided to give you CBE, and Andrew Mill was the partner. I called him and he said, no, I should give a much higher award. And he came back the next week. He said, Prime Minister said he can't give you the award, higher award, but he had asked the Lord Chancellor and he's prepared to nominate you. So that is where the problem came in. And he was scared that his theft might be found out. And consequently, then he made the allegation that I had given money to one of the ministers, British government. It's impossible to give. I can tell you that the British government ministers, at least in those days and even now, there's no corruption at all. But it was a great experience for me because it gave sort of the newspapers came in. And if that had not happened, then possibly I would have been in the House of Lords, because after me, Mr. Bagri came in. Bagri was nominated, and the press made allegation against him of corruption. But he stayed quiet. But I fought it out. I was pretty young. I was in my 30s. I fought it out. And there was a commission, parliamentary commission on inquiry. I gave evidence, and they found there is nothing. But this is how obstruction one had to face. I can quite understand, because people at that time were not ready to see a black face rising.
Right.
But it was fun and game, and I enjoyed it thoroughly.
What doesn't kill you makes you stronger. What doesn't kill you makes you stronger.
It gives you the ability to fight bad times with the good times, and to balance the whole thing. And you must have a greater object in mind, not just money making or not just promoting yourself. See, today we are respected. Today our firm is known for doing the most difficult cases. Venezuela, we are just now acting for Central Bank of Venezuela against Bank of England, and for the return of 31 tons of gold. Now, this is the kind of cases only the top international law firms handle. People come to us now. So we have reached a stage where...
So tell us about that case.
Well, Venezuela deposited about 5 years ago 31 tons of gold in Bank of England. Bank of England has a security vault to keep gold. And they wanted to sell half of it for using it for COVID. And the Bank of England says, sorry, we will not give it back to you because President Trump and my Prime Minister Johnson does not recognize your president as being properly elected. So they said, no, we're not giving it back. And they went to the big law firm and said, you can't take on Bank of England. We took it on. We lost in the High Court. We won in the Court of Appeal. Supreme Court was a draw. It's still going on. Let's see what happens. We are actively following the Venezuelan situation. Similarly, when the Iran bank Melat was for many years under sanctions, they lost at the High Court, they lost at the Court of Appeal, and the Supreme Court, they came to us and we won. And we're a small firm, and for them to come. Now, that is where we have reached today as an Indian firm, and I'm proud to say we are an Indian firm. We are an international firm, but Indian origin firm.
Right. So the point you make over there, which I need to understand a little bit, is that you can have sanctions, and sanctions are seen as an act or a decision by one government against another. It's not one people against another. Yet, they have to follow the rule of law. And I think this became the issue over there. So, can you explain that a little bit more in detail?
See, in England, the judges are very independent and very, very fair. And at a higher level, very informal. I'll just give you an example of what happened in the Iran case. When I was in Tehran, the chairman of the Bank Melat, which is Iran's biggest bank, said that we don't know what are the allegations against us. Now, 2 weeks before the hearing in the Supreme Court is normally 5 judges. I wrote a personal letter. Now, this is allowed to some extent. I wrote a personal letter to the Lord Chief Justice of the Supreme Court, and I said this is saying it is totally unfair. And I copied to the other side, the government, of course. My counsel, Michael Bindel, was very upset. He said, how can you write? But 2 days later, the Deputy Chief Justice called me up. He said, Lord Neuberger has got your letter. He knows me. We know each other. And he has decided to vacate the hearing and bring it before 9 judges. And we won 5-4. And the Supreme Court said that the British government had acted unlawfully and irrationally to list Bank Melad under the Iran nuclear sanctions. And we won. And can I tell you another thing which we did? Now, this is quite unusual. We settled it, or the case. We made a case of 1.6 billion pound damages against the UK government. Now, this is an English law firm suing the UK government. But the judges are very fair. And we were quite nervous whether we'd succeed because there were going to be 35 Iranian witnesses and you never know what they will say in cross-examination. And we settled the case 2 days after the hearing started. And the council had asked for an adjournment. The British government council had asked for an adjournment on the basis that the Prime Minister has to be consulted for the settlement. On 1st July, we had a consent judgment, and the payment had to be made. I can't name the figure because it's quite a large sum, it's confidential. And 31st July, Bank of England was going to pay. Iran told me that they are not going to pay, and and Iran has spent about 32 million pounds on the cost. And the British government said they had spent about 42 million pounds on the legal costs. And I said, leave it to me. Time came, payment didn't come. And you know what we did? I wrote a letter to the Chancellor of the Exchequer, Sajjad Javed, copy to the Prime Minister, and saying the Prime Minister was publicly aware that this settlement and agreed to term the payment is to be made by 31st of July 2019. And if he doesn't pay within 7 days, then we are going to obtain an arrest warrant against the Prime Minister and the Chancellor. And,
Wow.
and believe it or not, and only my firm would do that, believe it or not, we wrote this letter on Friday. Next Thursday, the payment was made, but not by Bank of England, but by Turkish government to denominated account. So these sort of things are there, but the important thing is that the judges are completely independent and fair, and I would trust the judges. They might get it wrong, but there is absolutely no corruption, there is no bias. And the rule of law is, everybody is under the rule of law.
There was another point in this particular case. I have to refer to my notes because it's a technical point. CMP, closed material procedure, of which we have an equivalent over here, which is sealed envelope. So if the government is involved, there are certain matters that they want to apprise the bench of, are not revealed in the open court. They're handed over to the judges. Is this an analogy to that?
Yes, it is. It is. In fact, we have a case just now because the former president of one of the Croatian countries, Yugoslavian country, has come to us because there are allegations of corruption against him. So he has not been allowed to enter. He's been sort of put on a blacklist. And we are acting for him. But there is a procedure called special advocates. They act for you. The government shows them the evidence. And they will only communicate with you what is necessary. But it works quite all right. And the special advocates are very independent because we had in the Bank Melad the same thing. And
Yeah.
it works.
Yeah, but there, were they finally forced to reveal what they had given?
Not to my client,
I see.
but to the special advocates, because they are appointed by government to act for my client under our supervision, but they will not give us what is the evidence.
Okay.
They are called special advocates. It
Yeah.
works all right.
Yeah. But the plaintiff is made aware of what is going on. It's not just the defendant.
Yes.
Yeah,
That's-
which is fair.
Which is fair. I think the judicial system is very fair and very open. That's one thing you can be sure about it.
Yeah. Because here it's now become pretty common practice when the government is involved in a case for them to hand over a sealed envelope and the other party has no clue what's in that envelope.
But only when there are issues of security or deep corruption, not everything.
You can bring issues of security to bear on anything.
That is true.
And that's what's been
It is happening.
happening over here. The other case that, in a sense, bears also on the same matter of the sanctity of courts and the impartiality of courts is, again, I'm going to have to refer to my notes because it's a Russian name, but there was this case of Dobrovinsky. Would you care to talk about that a bit?
Well, Dobrovinsky is the top lawyer in Russia. He acts for all the oligarchs. And he was being sued in the English court by there's a fraud against him alleged for fraud and theft. And Abramovich sold some assets. and there was a claim of $540 million against him. And he finally came to us. He didn't immediately. He went to the big firms, and then finally came to us, and we succeeded for him. There's also a reported judgment. So today, although we are from India, most of our clients from all over the world, and we do a lot of work for Russia, Ukraine, and that is what one has to do.
Okay, so let's talk a little bit about India. You've done some cases both in India and with Indians, and there was this very interesting case, the Oceanics case, which involved a Benami firm.
Transaction.
A Benami firm actually. And the point you make over there is that there are laws against Benami transactions, but they don't really work. And in this particular case, you actually had to sort of come to India. So could you give us a little bit of background and then how it finally panned out?
Well, I've always believed that law is for justice and not justice for law. I think it's a mistake for lawyers to say this is the law, this is the law, this is the law. Common law in England allows us to sort of interpret the law to feed the justice, and the judges support us to do that. Now, this was a case, I had a call from Crawford Bailey, which is a big firm of solicitors in Bombay, one of the oldest firms of solicitors in Bombay. There was a company called Oceanus, I can reveal it because it's in a public knowledge now, and they were into the oil drilling equipment at the Bombay offshore. And they had started an office in Bombay, but in those days, it's about 20 years ago, it was not permissible for overseas businessmen to start an office. They had to take a license for the Reserve Bank, but they had not taken a license. So what they used to, they had an employee, Indian employee. So they opened the office with director as an Indian employee. And the Indian employee was claiming ownership of it, and there was over 4 or 5 million pounds of assets. And they went to Crawford Bailey. They said, under the Benami Act, Benami means name of somebody else, you can't enforce your right to the court. The court will not recognize you. Now, what do you do? So they came to me, so Crawford Bailey asked them to go to me and see if I can find a solution to this. And I came up with a solution. I got Fali Nariman. I spoke to Fali Nariman, who is a good friend. And Fali gave me an opinion in writing that although under the Benami Act you can't sue, but the property still is owned by the original owner. So I get an opinion from that, and I told the client, English client, you come along with me, and I had an Israeli solicitor with me working at that time. So we went down there.
So you flew from the UK to India?
Flew to Bombay, we planned it. And I knew a Parsi, I'd read about him in the newspaper, that a Parsi assistant police commissioner contractor started a security company in Mazgam. So I went and met him. I said, will you give me 10 of your people, and I want them with a stick to come to New Bombay where his office was. So we went down there with English, and with the police note, I went to the police office to see if any police officer will come with me. And he said, no, this is too dangerous. You better go and see the assistant commissioner. So I met him. Fortunately, at that time, it was just after Bofors, so I was quite well known. So, and the police assistant commissioner himself came with his revolver. We went down there. We took possession of the property. And that was the end of it.
This is almost like street violence, Sarosh.
No violence, street violence. But we planned it, but to do justice, because that chap, he was a crook.
Well, it was, I'll play the devil's advocate over here. It was implicit violence, right? You had men with lathis and so on.
Just to show.
Yeah, right.
We did that.
Okay. So
what the message I would give to everybody is that the most important thing is to be honesty, and the character, good character, is important, because today we are respected in the English code. All the judges know that whatever we do is for justice, and I would never mislead the court. I would never, if a client is dishonest, I would say I'm not acting for you. So once you build that reputation, things become much easier for you.
You have all this experience in various international clients and fora. But I want to go back to one other Indian case, which I found really, really interesting, which was set in the UK. And again, in a sense, it was Benami. There was a solicitor. There was this purveyor of saris, and They were swearing black and blue until you sort of confronted them in a very unusual way. Will you talk about
There
that?
was a Bombay, I'm talking about this is 25 years ago, when it was not possible for Indians to start business overseas without the permission of the Reserve Bank. And what used to happen is that they would get some Brit, an Indian Brit, to start the company in their name. And there was a Sariwalla from Bombay, and he started a shop in Wembley. And he had taken an Indian junior solicitor as a Benami name. And then there was some VAT fraud, and the Indians at the end said, "This is not my company, I'm not a shareholder." So there was a big dispute. It didn't go to court. So they both said, "Let's go to Zaiwalla and find a solution for mediation." So I did a free mediation. And I found that all the documents supported the Indian chap, that he had nothing to do with it. But something inside told me that a solicitor, Indian solicitor, he was some East African Indian, he was honest. So then I started to, how do I do it? I'm a mediator, and I don't know whether you know, but I also represented India on the International Court of Arbitration as a judge for 3 years. So then I said, how do I do it? So I changed the topic. In the middle of a mediation, I started talking about God and spirituality. And they were both Gujaratis, and we were talking in Gujarati. And I asked both of them, who is your family God? The most Gujarati Hindus will have a family God, and they respect. So they both gave the name. Then I said, I'm giving you an oath on your family God to tell me the truth. And the Indian Sariwala from Bombay was so upset. He said, how can you do that? And he got so wild, but he admitted that he was in the wrong. It was that the company owned him, and the whole thing was resolved. So there are ways and means to do justice, not necessarily to court.
Sarosh, it's lovely to learn that you're still an Indian at heart.
Of course I'm an Indian at heart.
Despite being Parsi, you had an insight into the Hindu sort of way of doing things.
I think a message which I would give to all, that we are all one human being, and that's what we are working for. What matters in today's world is color of the heart, and not the color of the skin, religion, or flag. But we have to be honest and integrity. If there's money is not the only thing. As a lawyer, you don't have to succeed, but get justice. And I'll give another example. About 3 or 4 years ago, I had an Iranian group came to me, and they had a claim against them. There was a criminal charges against them of about 83 million. Iran state had bought an oil rig for 83 million, and the oil rig documents were delivered, the letters of credit was cashed, and the chairman of the Iran State Corporation then fled Iran. So the Iran government was suing or trying to freeze the accounts. And the first time when the team came to me, I was convinced that they were all innocent people. The second meeting, I realized that they were all crooks. Now, I decided I'm not going to act for them. So I simply said, there's a lot of work, I can't go somewhere else. So I will not act if I find that there is dishonesty. And it's completely wrong to suggest that any lawyer to think that they have to win at all costs. What we must try and do is to bring justice, and remember that law is for justice and not justice for law.
Sarosh, contrasting the situation 40 years ago when you first went to the UK and now you have your son Varun who's here, easing into your profession in London. How has the situation changed in terms of acceptance of brown people in the central mile of London?
See, we must keep it in mind that most of the brown people now in the legal profession are born in United Kingdom. So they have the English accent, they have the English values, and most of them are East African Asians. In fact, lots of them, or they have come to the second generation, and they are not finding it difficult at all. When you come from India, there's a complete different accent, different thinking. So when I started, it was completely different, and I recognized that, and I respected that. And the most important thing, also in England, is that you're free to say what you want, but always be courteous, no screaming and shouting. And once you have a reputation of courtesy, everything is fine. So the situation now is much more open, but this is because the majority of the young generation who are now in the 20s or 30s are born in England, grew up in English schools, and they are really British.
What a wonderful journey, Sarosh. I'm going to now offer an opportunity to people. There are already hands up to ask questions.
Sure.
First, the lady in the third row, if you can get a mic to her.
Welcome, Mr. Zaiwalla. I read your book. It is not only very fascinating, and your career, mesmerizing escalation to success, is absolutely keeps spellbound. Uh, there is one episode in your book which talks about the Bofor's kickback and the controversy about Ajita Bachchan, how they fell from favors from the Gandhis. So can you just, because it is a matter of mystique to Indians and a matter of curiosity.
Sure,
So
we have
can
the
you
question.
just elaborate on that a bit?
When my book was launched in Delhi in December 2019, when Mani Shankar and about 300 journalists, we had a 3 hours session and 2.5 hours on where is the Bofor's money. There was no doubt there was a kickback, and $64 million had come of Indian funds in somebody's pocket. But I am unable to talk about it for professional privilege. And that's something which I cannot give information on the client's case. But as I said in the book, as I've said more than what was permissible. It was what was permissible. I said in my book, and so it happened.
Okay, there was a
Can I
kickback.
just tell you the story? Because
Yeah.
after the Bofor's case was judgment was given, I was in Bombay, and my little son was at that time 7 or 8 years old, 9 years old, and P.C. Alexander had become the governor of Maharashtra. Before that, when the Bofor's was going on, he was the High Commissioner. So he invited me for tea. And during tea, he said, VP Singh is our guest here, and he would like to meet you and say hello to you. I said, yeah, sure. So Varun and I had nearly 3 hours meeting, private meeting with VP Singh. And I found him to be a very honest and very sincere person. And he told me exactly, words he told me was, I asked him, why did you do this? Because he resigned and all this thing. And he said, I was the finance minister of India. And my ambassador from Berlin told me, he phoned me up and told me that in the submarine deal, there's a big kickback and it's gone to one of the political leader of India. So I went to my Prime Minister Rajiv, exact words of his. So I went to my Prime Minister Rajiv Gandhi and I said, this is what has happened, this is India's money, what should I do? He said, leave it with me. So I didn't do anything. Then some 3 months later, the Swedish ambassador phoned me up and he said there is a $64 million kickback and the monies have gone to an Indian politician or something like that. So he said, I went back to my Prime Minister, Rajiv Gandhi, and he said, leave it with me. He said, I couldn't then remain silent. And then he went public and he made the allegation against the Prime Minister. Now, I am unaware as to who was the actual beneficiaries of that. To be honest, you can only have conjecture, so therefore it's very difficult for me to say anything more.
Fair enough. We have a question there from the gentleman with the hat there, and then the gentleman with the hat here. Okay.
I can only add that if I were to wind back the thing, it would have been much better if we had not acted for Bofors, because what happened? But it was a completely different journey. Because of acting for Bofors, when VP Singh came into power, Kuldeep Nair gave me a choice whether to continue to act for Bachchan or Indian government, and we were sacked from the Indian High Commission.
Whoa. We have a question from the hat.
So, I have a question. So, what is your, opinion around what is happening in India as of now, around that collegium system wherein, government is in a way pushing back, asking government that, their representatives should be part of the collegium. And then recently, yesterday,
We have the question. Let's see if Sarosh would like.
I think I would go with the collegium system because we must trust our judges, and that is very, very. This is in England, because once you get government interfering, then you're going to have judges who are appointed who are friends of the government ministers, and that must be avoided. Today, people from all over the world, parties from all over the world come to England for justices because the judges are completely independent. And the government has no say in the appointment of judges. It is the Supreme Court judges and the collegium decides, and they are very, very strict about their reputation.
I just want to add one fact, which is that something like 70% of the cases in Indian courts, one of the litigant parties is the government. So if you had government-appointed judges, it would be the judge who is both the litigant as well as the judge, and that's clearly not a way to go. This gentleman here in a beret, and then you, ma'am, yeah.
Sir, anything on Vijay Mallya or Nirav Modi? What exactly is happening?
Well, I met the new High Commissioner, Doraiswamy, about 7 days ago, and the first thing he raised is, can you help us? And I said, the answer is no, because Vijay Mallya is an old friend of mine. And therefore there will be a
Okay, the lady here.
In fact, we had our 40th anniversary at Victoria and Albert Museum with 350 eminent guests, and Vijay Mallya was one of them. And Vijay phoned me up. He said, Sarosh, I want to come, but would you mind if I come and the High Commissioner walks out? I said, look, I've invited you, you come.
Good afternoon, sir. I'm Dr. Anju Gehlot, and I am Assistant Professor in Department of Law, University of Rajasthan. And sir, I want to ask your opinion and importance and scope of equity, justice, and good conscience in present legal scenario
In India?
in India.
Well, I'm unable to judge because I don't have much experience. But from when I was in India as a student, younger days, I think the Indian judges are very, very fair. And I don't know about because I haven't.
Fair enough. Sir.
Good afternoon, sir. I am Mr. Nikhil Desai from Mumbai. And sir, I would like to ask your opinion about government asking for review of Keshwanand Bharti case in fundamental Constitution of India.
I don't know anything about the Vishwanath Bharti case, so I'm unable to comment unless you tell me what is the issue.
It is the judgment given.
I don't think we'll take that here. It's a very broad issue,
Yeah.
and since he doesn't know about it, there's no point bringing it up. I think
I've not been
it's
following-
critical, so I'm not trying to say it shouldn't be, but this is probably not the right forum. Ma'am?
Sir, it was really it was a great experience listening to you. You said that you should always go with honesty. That should be the lawyer's dictum. But is the truth always very black and white?
No.
I mean,
no, but your conscience will tell you whether the truth is black and white. And therefore, you must follow your conscience. For
But,
example, if you come to me and say, this is the truth, I will accept it. But if during the course of our acting, I find that you are not speaking the truth, then it will change my view.
Sometimes both the parties are wrong or untruthful. What would you do then?
Well, then, but I would, if I know that my client is being untruthful, I will cease acting for him. If I find out. I'll give you one example. There was an Indian shipbroker, I won't name him, and it was in the middle of the hearing. And the judge asked for a forensic investigation of his tape recording. And he told me that, look, it's a fraud.
Wow.
And I had to, and it was an adjournment. I said, no, you must withdraw. And I insisted on that.
We have time for actually one more question, but
Yes,
we'll
sir.
take two. No, this lady here.
Yeah.
This lady. No, the next one. Yeah.
Thank you so much. Great insights. I'm a lawyer from Australia and I lead an organization called the Asian Australian Lawyers Association. I'm the national president. The issues we grapple with in Australia is unconscious bias and the bamboo ceiling, because the bamboo only grows up to a certain level and you know, Asians only progress to a certain level because at leadership level there's a lot of unconscious bias. So did you experience something like that in the UK as well? I know it's pretty progressive as compared to Australia, but I would still love to hear your views.
I think there was not unconscious bias, not amongst the judiciary, but amongst the members of the legal profession, there was an active bias. And I had more than once told by senior solicitors, because we did a lot of Indian High Commission work, that we don't mind you, but we don't want more of you. And it has been told to me, and it is very, very clear. Things are changing now. People are becoming more tactful of what they say because of the race relations law. But we have to recognize that the new generation is completely different from the old generation. And we mustn't recognize they were ruling, that we were colonies for so many years. And suddenly you find to accept everyone is not easy.
I think he talked a lot about that in the early part of the speech, and there's a lot there. You have to be savvy, you have to get political, you have to get involved. We'll take a last question from this gentleman here, even though we're out of time. And
I'm Dr. Mohta from the Indian Foreign Service. Hi, Sarosh.
Hi.
Sarosh, you have a view on government stepping into appointment of judges. But what about judicial activism? What about judges stepping into area of executive and legislative privilege?
Well, in England, the judges are allowed to actively step into, because the judges have to bring justice. And in England, judicial activism is very, very there. and because people trust the judges. And I have, in fact, one of the reasons why we have succeeded, because I come with new points, because I'm confident that if the judge finds that there is merits and justice in it, then the judge will even override the law if necessary.
Thanks. We're done with time. Thank you so much, Sarosh.
Thank you very much.
Thank
all
you
of
all for being so involved.